Welcome to Advanced Care Planning and Personal Directives. This is a video presentation by the College of Licensed Practical Nurses of Alberta and Alberta Health Services. I'd like to introduce our facilities for today. It's Alexandra Kushlak, that's myself, and Jennifer Zellmer. My background is social work, and I've been in the field for over 35 years. I've worked in various facilities from acute care to long-term care, and have helped many clients and patients to do a personal directive. And of course, I've got my own personal directive and have experienced with it in terms of using it with family members and making sure that everybody that I know over the age of 18 have a personal directive. I'm going to have Jennifer introduce herself and give a little bit of a background.
Wonderful, thank you. Yeah, hello, my name is Jennifer Zellmer. I'm your other facilitator for today, and my background is nursing. I've been a registered nurse for just over 15 years, mostly in acute care working with adults. I've kind of been everywhere from medicine to surgery to the intensive care unit and done a little bit of outpatient work as well. I'm too pretty passionate about this topic because in combination with my professional career as well as in my professional life, I've really seen how having a personal directive and how advanced care planning is really part of providing patient and family-centered care. So we've been very fortunate to be invited by CLPNA to provide a series of video presentations for LPNs in Alberta. So we've broken it up into 3. So today our first topic is going to be advanced care planning and personal directives. So this graphic just kind of shows how all of these topics are really integral to providing care that's consistent with patient values and providing patient and family-centered care. So we have advanced care planning, which we're going to be focusing on today, which is really a building block towards our goals of care and our healthcare that we provide to patients. And then the documentation piece, which is the green sleeve and the related documents, really is the important part of communicating this important information with patients as they travel along in our healthcare system. So again, today, as I mentioned, we're going to be focusing on the advanced care planning part of that equation. So the topic for today and kind of the plan for today's video is we're going to look at advanced care planning. We're going to spend a lot of time going through advanced care planning on a personal level for yourself. So talking about why it's important, and we're actually going to give you the tools you need to write a personal directive for yourself if you haven't already done so. Then Alexandra is going to go through in a little bit more detail what you need to know about personal directives when working with patients or clients in your practice. So to start off, what is advanced care planning? In general, only about 2 out of 10 Canadians really understand what that term means. So basically what advanced care planning is, it's a process where a capable adult plans for a time where maybe they're not able to make their own medical or personal decisions. So it's basically thinking about your healthcare wishes, thinking about what you may or may not want for healthcare treatment, and talking with people close to you so they're aware of your wishes. It's also about choosing somebody to make decisions on your behalf if you ever become unable to speak for yourself for some reason, whether that's temporary or something permanent. And then the final piece is documenting this information in the personal directive, which is what makes your advanced care plan legally binding. So part of the reason why this is so important is because our healthcare system has changed so much in the last 75 to 100 years. So the slide you're looking at right now is a death trajectory, and this is where we used to be. So this is sudden death. So, you know, we're fully functioning and then something happens and we pass away suddenly and quickly. And this used to be the norm. Most people died this way because medicine could do very little in terms of curing disease or illness, really until after World War II. So there was very little decisions to be made, and people often passed away quickly from relatively minor things that we're now able to treat. So this is where we are now. So looking at these 3 trajectories, whether it's terminal illness, organ failure, or frailty, this now accounts for over 85% of deaths. And what that means, because when you look at these 3 trajectories, what they have in common is it's a longer period of decline over a greater period of time. So when you combine that with the fact that medicine has so many more treatments, options, there's new drugs, there's new trials, there's new approaches, that in combination with disease taking longer, it means there's more decisions to be made. And we can expect this for most of our patients and for ourselves as well. So really makes advanced care planning quite relevant, because we need to now be thinking about what we want for medical care, because there's more decisions to be made. So advanced care planning involves 5 steps. So you're going to see them on your screen here. So the first step is thinking about your wishes and values for healthcare. So a great place to start with this is looking at your experience working in healthcare, or thinking about experiences you've had in your personal life, either for yourself personally or with those close to you. Experiences with being in hospital, with being ill, with death even, thinking about what you felt was good medical care and what you felt was not good medical care. It's a really good way to start thinking about what you may or may not want for yourself. The second step is learning about your own health. And this is really important. So if you're young, if you're relatively healthy, your advanced care planning is going to be very different than if you've been diagnosed with a disease or if you're facing end of life. So if you're healthy, really your personal directive and your advanced care plan is very future oriented and thinking about, well, if this happened, what would I want or what would I not want? But if you've been diagnosed with something, it becomes really important to learn about that illness, and learn about what decisions might be coming down the road. Because ultimately, if you don't know what's going on with your health, it makes it really difficult to plan. So the third step is choosing that alternate decision maker, someone to make medical or personal decisions for you if something happened where you became unable to make your own decisions. And in Alberta, the legal term for this person is your agent. And that's what I'll be referring to this person to for the remainder of the presentation, is your agent. So the fourth step is communicating your wishes and values about healthcare. It's really important for your agent to be aware of any healthcare wishes that you've thought about for yourself. It's also really important for other people you're close to be aware as well. Because if your agent or your loved ones ever had to make decisions for you, they need to have an idea of what you would or would not want. So I think the fourth step is probably the most important out of all of them. And then the fifth step, the final step, is that end result, which ends up being the personal directive. So this is where you write down your healthcare wishes and you write down the name of your agent so that it's legally enforceable. So when we educate the public, because that's part of our role as well, we find that there's a lot of confusion about the different types of legal documents that are used in Alberta. So we like to always start by doing a quick recap of the differences between them. So in general, you need 3 legal documents in Alberta. You need a will, an enduring power of attorney, and a personal directive. And they all serve completely different purposes. So a will, it doesn't even get looked at until after we've passed away. It has to do with our money and our estate after we've died. So it has nothing to do with our healthcare, which is really important for you as healthcare providers to be aware of, because oftentimes the public thinks that if they have a will, it's the same as a personal directive. So they might try to brush you off and be like, I have my will, I'm okay. So it's really important to know the difference, to be able to tell people that a will is not the same and it has nothing to do with healthcare. So the second document there is an enduring power of attorney. So this document does come into play while we are still alive, but it only has to do with financial or money decisions. So an enduring power of attorney allows you to name a decision maker called your attorney, but they only have authority over money matters. So they can't make decisions about your healthcare if you've written their name in an enduring power of attorney. So now the third document is the personal directive. And this is the document that comes into play while you are alive, but unable to make your own decisions about personal matters, which includes healthcare. A personal matter is anything that's non-financial. So it's things like your healthcare, where you can live, who you can associate with, can you go to school, can you work, maybe some legal matters. So it's a wide range of decisions. So really, really important to be sure that you have a decision maker in place that you trust. So again, just to recap, what is that personal directive? It is not the same as a will or an enduring power of attorney. It has a very specific purpose. It's a legal document that allows you to appoint your agent to make healthcare and personal decisions if you became unable. And it's also the document where you can write down healthcare wishes that you would want people to know and follow if you were unable to speak for yourself. And I should clarify that you can have the same person listed as an agent in your personal directive, and that same person can also be listed as your attorney in an enduring power of attorney. So you can have the same person making different types of decisions for you, but you would need to write their name down in both documents. So myself, for example, if I wanted my husband to be in charge of my financial matters, I would have to do an enduring power of attorney with his name. And if I wanted him in charge of my healthcare and personal decisions, I'd have to fill in a personal directive with his name as my agent. So he'd have to be written in 2 separate documents to be able to make those 2 different types of decisions. Okay, really important to know about a personal directive. Writing a personal directive does not automatically mean that you are no longer in charge of your personal and medical decisions. We find when we educate the public, sometimes that's a deterrent. People are afraid to write a personal directive because then they think that they lose their decision-making power. That is not the case. If you write your personal directive, it only comes into effect if it's been proven that you're unable to make your own personal or healthcare decisions. And that requires very specific assessments and documentation to be done in part by a physician. So it's not automatic. There's a process in place to activate or turn on your personal directive. So a couple of things about a personal directive before we get into walking you through how to write one yourself. You are able to write your personal directive without a lawyer. Oftentimes, if you go to a lawyer to say get a will done, lawyers will often do a will, an enduring power of attorney, and a personal directive all at the same time. They combine them. So if you've gone to a lawyer in the past and had a will done, you might actually have a personal directive completed already. But if you don't, a personal directive can be done either with a lawyer or without a lawyer. It's completely up to you. So with your personal directive, once you write it, it's really important to keep the original in a safe place because you don't want anything to happen to it. But it's really important to make sure that there's copies out there. You want to make sure that your agent has a copy, that your family or your loved ones have a copy. It's a good idea for your healthcare providers or your doctor to have one. And it's a good idea to have one in your green sleeve if you have a green sleeve, okay? Because your personal directive is not going to be very helpful if nobody can access it. So now we're going to go into writing your own personal directive and kind of walking you through what you can write in it. So getting started. It's really important to know that in Alberta, there is no standard format for a personal directive. So they can look many different ways. They can look like a standard typed up legal document. They can be handwritten on a piece of paper, or they can be written on a variety of different templates that exist out there. As long as it's signed and dated and witnessed, it is a legal personal directive that's valid and that should be honored. Okay? Even if it comes from another province or another country, or even if it's titled something different, as long as it's signed, dated, and witnessed, we should be honoring it. Now, you might find in Alberta Health Services, we tend to use and provide the personal directive template that's been developed by the Office of the Public Guardian. It's a really nice personal directive template because it has an instruction sheet and it's broken down section by section. So it really walks people through what each section means and what you should be including in that section. So that's why we've elected to use it. So in green sleeves in Alberta Health Services, there's a blank template from the Office of the Public Guardian, which is, like I said, quite user-friendly. So that being said, it's always important to make sure you check your documents. If you are wanting to write a new personal directive, take a look, because like I said, if you've had a will done before, go take a look if there's a personal directive in there. If you're still happy with what it says, there's no need to redo it on this Office of the Public Guardian template or any standard form. So any personal directive has kind of 4 key elements. So there's a revocation of previous personal directive statement. It's where you can designate your agent. There's a section about designating your agent. There's a section where you can write healthcare wishes. And then there's the witnesses and signatures, which makes your personal directive legal and valid. So revocation of previous directive. So whether you're using a template, whether you've gone to a lawyer, or whether you're handwriting your own personal directive, just even on a blank piece of paper, either automatically there will be a statement included, or you need to write one, some sort of statement saying that you revoke any other previous personal directives that you have written. It's really important to do this because writing a more current personal directive doesn't automatically void a previous one. Okay, the rule of the most current trumping all others does not apply here. So it's actually possible to have two personal directives in effect if you don't write a specific statement saying, I void all other ones. So really, really important to be doing that. And if ever in future you want to make a change to your personal directive, maybe you want to change your agent, maybe your healthcare values have changed. If you're just not happy with it, it's always good to write a new personal directive, put that statement in there, voiding all others, rather than editing a pre-existing personal directive. Because if it ever gets called into court, it just looks like it's been tampered with. So it's always best just to do a fresh one rather than trying to edit a previously written personal directive. The next key element is designation of agent or agents. So your agent really can be anybody you want, okay? They do need to be at least 18 years old, and they do need to have capacity, because if they don't have capacity to make their own decisions, they can't be making decisions for you. But what you really want to be thinking about is someone you trust, okay? Your agent does not have to be your spouse, does not have to be your partner, doesn't even have to be a family member. What's most important is thinking about someone you trust and someone you feel comfortable sharing your wishes with, and someone that you're confident will respect your wishes even if they don't agree with them. You do want to think about somebody who can be contacted. So your agent does not have to live in the same city as you. It's ideal if they do, because then they're close by if something happens. But as long as we can contact your agent, they don't have to live close by. Cell phones have really opened up, how easily we can contact people. So as long as we can contact your agent, they don't have to be living close by. You want to think about somebody who can communicate well, and somebody who's not going to fall apart under a stressful situation. Because if they're ever called in to make decisions on your behalf, it's really hard, and it's most likely not in the best circumstances. So you want to think about somebody who's going to be able to think clearly even when they're under stress. Now, you can have multiple agents, which is actually a really good idea, but you need to be aware that how you write the names really matters, because we're dealing with a legal document here. So if I had my two friends or my two kids or whatever, if I wanted both of them to be my agent, if I wrote Mary Smith and Bob Jones, by using the word and, it means that both Mary and Bob have to be agreeing on every single decision that they make for me. They both have equal decision-making power. So if they don't agree, it can be a real impasse into a decision being made. So oftentimes we do hear that people, especially if, some of our elderly population, our seniors, they might want all of their children to be their agent. So they might have Mary and Bob and Steve and David. But we tend to discourage people from doing this, because the likelihood of everybody agreeing every step of the way is not, it's not great, and it can really become a problem if agents can't agree. So your other option could be if I wrote Mary Smith or Bob Jones. So the word or means I'm happy with Mary making a decision or Bob. It doesn't matter who. So if I'm in the hospital and Mary's there one day, if a decision needs to be made, Mary can go ahead and make it. Maybe the next week, Bob happens to be there. Same thing, Bob can make that decision as well. So either or, I'd be happy with either of them. Now, the third option, which is probably the best, is putting Mary Smith and then putting primary. So, and then Bob would be the alternate. So this gives a little bit of a ranking order. So by writing it this way, it means that Mary is my top choice. I want you to go to Mary first, but if something happens where maybe you can't get a hold of Mary, or maybe Mary falls apart and she just can't make decisions, or she refuses for some reason, then I want you to go to Bob. And then if I had a second alternate and a third alternate, it's just that ranking system so that healthcare providers know who to start with and who to go to next. So a couple other things about your agent is, again, like I mentioned, your agent should have a copy of your personal directive, because they need to know what's in it, especially if you've written any healthcare wishes. And they also need to be able to prove that they do have legal authority to be making decisions on your behalf. They should know where the original is. It's unlikely that they would need to produce it, but if there was ever a question about a personal directive being tampered with, then they might need to be able to produce the original to make sure that isn't the case. Your agent should know that you have picked them, and they should agree. You don't want this to be a surprise, because your agent can say no. There is no law stating that somebody has to be an agent just because you write them down in your personal directive. So really important to make sure you ask your agent and you let them know that you've chosen them and written them in your personal directive. And your agent also should note that they are legally obligated to follow your wishes if they're speaking for you. So by signing up to be an agent, there are some legal obligations involved as well. So some other legal obligations, I mean, if your agent is in a position where they need to be speaking for you, they do need to provide the personal directive to the healthcare team. They're the ones who are involved with, in discussions with physicians, with the healthcare team about your medical care, maybe, or about placement, where you live, who can visit you. They're involved in all of those discussions. They should be including you as much as you're able in decision making. So just because they're your agent and they're now making decisions doesn't mean that they should just be cutting you out of the picture completely. They should be including you in decisions as much as possible. They should also be keeping a written record of all decisions, which is really important for agents to be aware of. They're also legally obligated to be making decisions based on any wishes that they're aware of, whether they're written or expressed through conversations that they had with you previously. And if they don't know any wishes, they're always legally obligated to be making decisions in your best interest, which means making decisions thinking about, well, what would you do? Not what do I want to do? What would you do? And as healthcare providers, or even in your personal life, if you're ever concerned about an agent, if you feel like they're not acting in someone's best interest, they're not doing a good job, you can't contact them when you need, there's neglect, there's abuse, anything like that, you can put in a complaint with the Office of the Public Guardian and Trustee, and they'll start an investigation. So on your screen, there's the link. There's a form that you would fill in. You do have to provide your name, but when the investigation is started, it would be kept confidential. So if you did complain about an agent, they would never know that it was you who launched the complaint. So now we're going to move on to healthcare wishes. So in a personal directive, it's a great place to be writing some healthcare wishes that legally should be followed if applicable to what's happening, okay? If you've written healthcare wishes that make no sense to what's going on or have no bearing on decisions that need to be made, they're not going to be followed. But if they're applicable to what's happening, that's when they should really be informing care. But oftentimes people struggle with, well, what do I write? What kind of things should I write for healthcare wishes? And what we recommend is writing kind of value statements or quality of life statements. Oftentimes, personal directives will have statements that are very intervention focused, like no heroics, I don't want CPR, no tubes, no machines. And that can be helpful in some contexts, but oftentimes it doesn't apply to the wide range of decisions that an agent might have to make for us. So we really do recommend kind of writing broader quality of life statements that help your agent in a wider range of situations. So thinking about things like, what's most important in your life? What do you need to have in your life to give you joy and meaning? What does quality of life mean to you? What does no quality of life look like for you? Are there certain things that you could not live without? Is it being able to walk? Is it being able to eat? Is it being able to communicate with your loved ones? And are there any situations where you would not want your life prolonged? And what does that look like? So those sorts of statements, that's really the type of information that your agent would need to be able to make good decisions for you. That being said, there is reason in certain situations for a personal directive to be a little bit more specific. So for example, if you have a health condition, maybe like dementia, like cancer, where there's a known trajectory or a known pathway for how this disease will progress, then maybe you'll have a little bit more specific information and instructions about decisions that most likely will have to come up. So for example, if I was diagnosed with dementia, I might say, when I'm at a point where I no longer recognize my family, I can no longer eat anymore, I'm bedridden, at that point, I would not want you to prolong my life. So again, that might be a little bit more specific to what decisions I know will probably be coming down the road. So a couple of special considerations. These are questions that we get a lot when we're out educating the public. What about medical assistance in dying? And organ donation actually comes up a lot. And these are definitely related to advanced care planning, but they're also a little bit separate as well. So as of right now, medical assistance in dying, the law in Alberta states that we have to be competent and capable to request it for ourselves. And if you remember, I said earlier, your personal directive only comes into play after you've lost capacity. So if we're going by your personal directive and your agent is speaking for you, that means that you don't have capacity to request medical assistance in dying for yourself. So if you were to have written that in your personal directive, you know, I want medical assistance in dying, your agent cannot request it on your behalf because you have to be able to request it for yourself by law. So that being said, though, it is still good information to include in your personal directive because it does give good insight into your healthcare wishes and values. So for example, if you had said, you know, if I have dementia and I can no longer recognize my family, I would want medical assistance in dying. Even though your agent could not request that on your behalf, that's still pretty good insight, and your agent would probably be able to pull from that, well, maybe we shouldn't be resuscitating, or maybe we should be focusing more on comfort. So again, it still gives good insight into your healthcare values, even though your agent cannot request medical assistance in dying on your behalf. Now, organ donation is another interesting consideration. So organ donation, those processes don't really begin until after you've died. So once you pass away, the personal directive becomes irrelevant because you've passed away. Now we're looking at your will. So organ donation ultimately comes down to your family being willing to sign the consent forms to allow harvesting procedures to begin. And so again, it's a great thing to write in your personal directive, because if your agent and those close to you are aware that being an organ donor was important to you, that's really important for them to know. But putting it in your personal directive does not make it legally binding, and it doesn't force your agent or family legally to honor it. So again, it's important for them to be aware, but if they're not willing to sign the consent forms after you've passed away, it's not going to happen. So witnesses and signatures, this is the other mandatory component of a personal directive. So again, your personal directive isn't considered legal or valid until it is signed, dated, and witnessed. So your witness can really be anybody. It doesn't have to be a lawyer. It doesn't have to be notarized. You can have a neighbor, a friend, really anybody can witness for you. They have to be at least 18 years old. And what they should be doing is, if you're using a template where you're just initialing throughout the directive, they should initial everywhere you have initialed. Then they need to watch you sign and date the personal directive, and then they need to sign and date the personal directive in front of you. And basically what your witness is saying is, you are who you say you are, and you're not doing this under any duress. Now, there are a few people who cannot witness. So anyone you have listed as an agent in your personal directive cannot be a witness. The spouse or partner of anyone you've listed as an agent, they cannot witness. And your spouse or your partner, they cannot witness either. And it just comes down to kind of conflict of interest, or the perception of potential conflict of interest. Now, as a healthcare provider, as an LPN, are you able to witness a personal directive for a patient or a client? And if you are physically transcribing or writing a personal directive on behalf of someone who's not able to physically write it themselves, then no, you would not be able to witness it. But otherwise, yes. So it is fine, but it's just important to be aware that if you're witnessing a personal directive in a healthcare provider capacity, you're held to a slightly higher standard. So if someone's personal directive was challenged and it went to court, you'd be responsible to really kind of account for the fact that this person knew what they were doing, they understood the document. So just that slightly higher element, it's a degree higher than just saying, well, this person was who they said they were. Okay. So that being said, if you ever want to witness a person's personal directive, there's no other option, you can do it, but just make sure you document really well, something to the effect that, you know, this person understood the document, they understood the choices they were making. So just really trying to protect yourself through documentation. So now that's the end of my portion. So hopefully I've given you the tools to kind of think about your own personal directive and write one if you haven't already. Now I'm going to pass it over to Alexandra, and she's going to drill down what you need to know about personal directives when you're working in your LPN role.
So thank you, Jennifer. So I'm just going to go through what's important as your role as a licensed practitioner nurse, what you're looking for in terms of a personal directive, how to tell if a personal directive is activated, and how the activation of the personal directive impacts your practice, and what your role is in activating a patient's personal directive. So like Jennifer said before, there is no standard form for a personal directive, so which makes our lives kind of difficult as a professional, because it can be written, it can be typed, it can look like a legal document, it can look like a piece of paper, it can be handwritten, but as long as it's signed, dated, and witnessed, it's a legal document. So it can even be called something else. It may be in some places called an advanced care directive, even if it's coming from another province, as long as it's signed, dated, and witnessed, it's a legal form for Alberta. The Personal Directive Act specifies that in the Personal Directive, we can appoint someone to help in terms of deciding whether we have lost capacity or not. So when that happens, how the Personal Directive is activated is different than if that's not stated. So they're very specific in the Personal Directive Act in terms of what documentation you use. So if in the Personal Directive it states that your friend or your spouse or maybe your agent is supposed to determine your capacity, then that person would fill out a Schedule 2 along with the physician or psychologist. And these are very specific forms. We have them on the screen here for you as Schedule 2. So that would be if you named somebody in your personal directive to determine your capacity, always along with a physician or psychologist. If you left that part out, then it would default to a Schedule 3. So then it would be a physician or a psychologist would determine your capacity to enact the personal directive along with another service provider. If the personal directive stated that it needed to be 2 physicians, then that's what would be happening, and it would be a Schedule 3. So remember, the Schedule 2, it gets completed first by the person listed in the PD, and then the Part 2 gets completed by the physician or the psychologist. When we're filling out the Schedule 3, it's to be used when no one is listed or when 2 physicians are listed. So it would be completed by the physician and psychologist, Part 1, and then Part 2 could be completed by another service provider. The service provider is defined under the Personal Directive Act, and it includes licensed practical nurses. So what we need to look at is there a completed Schedule 2 or 3 to determine if that person's personal directive is activated. And we are only looking for that Schedule 2 or 3. It cannot be activated on a piece of paper from a physician or a letter from a physician. It has to be on those specific Schedule 2s or 3. So when a personal directive is activated by law, the agent makes all the personal decisions. So then we're going to the agent to ask them for consent. We're asking them to sign any paperwork. We wouldn't be going to the patient or the client. The agent has responsibilities. Jennifer talked about it a little bit. They must follow any of the healthcare wishes and instructions that are in that personal directive if they apply to the situation. And also as healthcare providers, we are also to follow the wishes and instructions written in the personal directive. So when we have a personal directive, sometimes in a personal directive, a person puts in there, I don't want to be resuscitated. I don't want to have CPR. But we can't just follow that. So remember, if something's in a personal directive that needs to be a medical order, we still need that medical order. So if somebody writes in the personal directive, please do not resuscitate me, you should be telling them to go to their physician, because that form needs to be filled out before we can actually follow it. So personal directives is your wishes and values, which we can follow up on, but we still need that medical order. We have a nice algorithm here for you to understand and have a quick look at what to do if a person's personal directive is activated or not activated. So if it is activated, we're looking for that Schedule 2 or 3, and then we're identifying the agent and making sure that the agent makes the decisions. If it's not activated, then we're looking to see, is the patient competent? Then the patient makes their own decisions. But if the patient is not competent, then we need to determine if it's the right time to activate the personal directive. So for your CLPNA guidance, the LPN can perform a capacity assessment for the purpose of enacting a personal directive. That means that you are allowed to complete Part 2 of the Schedule 3 document. But just because you're allowed to, we're caution you to make sure that you're well familiar with the documents and that you know exactly why you're filling out those documents. And a little thought is, would it stand up in court? So if you were brought into court, would you be able to defend that application or that documentation that you filled out? So if you're feeling that you're not comfortable filling out that documentation, you can certainly say, no, I don't feel comfortable doing it, and you don't need to do it. But an LPN cannot perform a capacity assessment when a patient does not have a PD and you're doing an application for guardian or trusteeship. It's a whole different document, and those capacity assessors do need some documentation that they are qualified to be capacity assessors. So in terms of resources, we have the Personal Directive Act, if you ever want to look up what it says, some of the definitions, but we also have great guides. Understanding Personal Directive is a great one to start with. It goes through all the things that you need to know when you're filling out a Personal Directive and some of the laws that go along with it. If you're feeling that you want to do the capacity assessment on the Personal Directive Act, the next guide is a great resource. It walks you through step by step in terms of how you would do that. Your own licensing board, the College of Licensed Practical Nurses, also have their own guidelines, which you can also follow. So why is advanced care planning so important? It's when we did some studies, we found 60% of Albertans have discussed what their treatment wishes are, what they want with their family, but only 20% of Albertans are actually talking to us. So we're not doing a great job of engaging people and having them talk to us about what their wishes are. So a great place to start is to remember those 5 steps. And if you've done those 5 steps for yourself, it's a lot easier to talk to your clients and patients about those steps. Explain what advanced care planning is and why it's so important for all of us. Ask them if they have a personal directive. Explain what one is. And you can always tell them, I have my own personal directive, and this is what I put in mine. And then also remind them that it's for everyone over the age of 18. It's not because somebody has an illness. It's not because somebody is a senior. So in terms of what can you do to start that conversation? Like I said before, some really simple questions. Do you have a personal directive? Do you have a decision maker? And do they know what you would want? Very easy questions to start that conversation. You can also give out our Conversations Matter booklet, which walks people step by step through in terms of those 5 steps. It's a really easy booklet to read. We just encourage you, if you're giving resources to your patients, please open the resources, point to different aspects in the booklet, point to the checklist at the end so that they'll actually use that booklet as opposed to recycling it. So one of our main gems is that advanced care planning and personal directives are actually the forefront and the beginning of patient-centered care. It directly impacts about if we know what our patient wants. It's important that you know if your patient has an activated personal directive. Are you going to the agent for consent, or are you talking to the patient themselves? And do you know who that agent is? So going through that advanced care planning process and writing your own personal directive makes this process so much easier. You'll understand when you see a personal directive, you'll understand the importance of it, because if you went through the trouble of going through a personal directive, making one, assigning an agent, putting in what your healthcare wishes, once you want it to be activated when it was necessary, and once you want the healthcare providers and the agents following what your wishes and values are. If you want more information, we have our website, Conversations Matter. They've got information there for health professionals and patients and families. So as a health professional, you can do our e-module, you can access the videos, you can also order any kind of resources you need or supplies, whether you're in Alberta Health or out Alberta Health. These are some of our references. You can go through them. Most of our information comes from the Office of the Public Guardian, and you can visit their website and where they have more information on personal directives. All of the images have been cited, and we have permission for them to be used. If you want more information or are wanting some of the documents that we've listed in our session today, please contact the College of Licensed Practical Nurses of Alberta. The emails are listed. If you have other questions, they will certainly directly contact us. We'd like to thank you for joining us today. And if you have any further questions, please contact the college. Thank you for joining.